Hi, my name's Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the fraud on the market theory. We're going to discuss this theory in light of two different securities class action cases, the first being Basic v. Levinson and the second being Halliburton. So just to kind of give you the facts of where a securities class action might arise, we'll just discuss the facts of Basic Inc. v. Levinson very quickly. I have another video on this case for the materiality standard, but just to get an idea of where we're at for class action. This is a case where a company was in merger considerations with another. The CEO denied that merger 3 times, and a bunch of investors sold their stock when that merger rumor was denied because they figured, well, there's not the upside in the merger consideration. Ultimately, the merger went through. These investors were all angry, so they brought a lawsuit, a class action lawsuit, with the help of some entrepreneurial plaintiffs' attorneys to say, hey, you owe us a lot of money. We didn't want to sell our stock. We sold it because you lied to us. You ended up merging with this other company. So in a class action in the federal system, it's governed by Federal Rule of Civil Procedure 23. And Rule 23b-3 requires that common issues of fact or law predominate amongst the class members. So that's important to remember because that's important for the fraud on the market theory and why it needs to be there. So there has to be commonality, common questions of fact or law amongst all class members, amongst all the people who sold this stock and are suing Basic. So Rule 10b-5 also, this is the anti-fraud provision of the securities laws, and this is based on Section 10b, but it's the SEC's rule that kind of lays out its vision of 10b more specifically. Rule 10b-5 requires a plaintiff to show reliance, amongst other things, when they are suing someone for securities fraud under 10b-5. So you have to show reliance, meaning you have to show you relied on the company's or the defendant's statement, whether that be an alleged misstatement or omission, when you bought or sold your stock, right? So you have to show that you relied. This causal connection is important to show, hey, your fraud, your alleged misstatement or omission is responsible for my loss, right? I didn't just sell this because I felt like it was a good day to sell. I sold it because of you. And so that's the important part, right? So you have to show reliance. So there's this conundrum in a securities fraud class action is how do you show reliance amongst thousands, hundreds, maybe tens of thousands of class members, right? How do you show that there is a common reliance? It's going to be very difficult, right? Because you have to show, you're going to have to go to each class member, discuss why they sold their stock. You have to get them to testify. That's just going to be completely onerous and almost impossible for anyone to do. So it's if reliance has to be individualized in a securities class action under Rule 10b-5, well, then there might not ever be securities class actions under 10b-5 because it's going to be too difficult, too onerous to prove reliance amongst all of the class members. And so what some academics and some smart lawyers came up with was this fraud on the market theory. They based this theory on the idea that in an efficient capital market, investors rely on accurate price, right? And the price is influenced by all information. So information influences price. So the fraud on the market theory is heavily influenced by the efficient capital markets hypothesis, which states that public stock prices reflect all publicly available information. And they do so rather quickly. Now, there's different variations of that theory, but the fraud on the market theory relies on that, and it relies on the semi-strong version. It doesn't need to rely on the super strong version of that theory where it says all information, public or private, is immediately reflected in stock price. It just needs to say that information that's publicly available is reflected in stock price, right? And so based on that theory, we get to this thing where if all investors rely on an accurate stock price, well, they're relying on the information that undergirds that stock price. And so if that information is fraudulent because of the defendant, well, then we can prove reliance for the whole class. And then we can get around this problem where securities class actions would be too onerous for anyone to prove, right? Or to bring. So in Basic Inc. v. Levinson, the court adopts this fraud on the market theory. They say, we're going to sanction this. We're going to say, if you want to bring a securities class action, you can prove reliance by showing that there was fraud on the market. And this theory gets teased out in subsequent cases, but essentially to get this presumption of reliance in a securities fraud class action, you have to prove, one, that the alleged misrepresentations or omissions were publicly known, meaning they were publicly available. 2, you have to prove that those misrepresentations or omissions were material. This is just classic 10b-5 that has to have materiality, meaning that it would influence a reasonable investor, right? 3, you have to show that stock traded in an efficient capital market. Now, this is really important because if the stock doesn't trade in an efficient market, like a private market where there's not a lot of volume, like there would be on the New York Stock Exchange or perhaps the NASDAQ, then you're not going to get this. The publicly available information isn't going to reflect stock price as quickly as if you're in an efficient capital market. And that's important for the efficient capital market hypothesis as well. And then 4, the plaintiff just needs to show that they traded between the misrepresentations or omission and when the truth was publicly revealed. Now, the defendant in basic says that this presumption can be rebutted by severing the causal link. So you might do that by showing that there was no price impact. So you could say that although this misrepresentation or omission was publicly known and our stock was traded in an efficient market, the plaintiff bought during the fraud, and yeah, it's material, but it didn't impact the stock price. And so you can see this is going to be a pretty rare scenario where someone can prove that this misrepresentation is material, but it didn't impact the stock price. But if you can get an economist to come in there and do some highly complicated mathematical analysis and present it to the judge, well, then you might say, hey, look, there's no reliance. We're not going to get class certification, get rid of this case right now. And so you can see why this might be controversial. First, it might be controversial because Congress never wrote anything about the fraud on the market theory in Section 10b. The SEC never really wrote about it in 10b-5. This thing kind of just came up and the courts adopted it. So there's not really this congressional creation or sanction of the fraud on the market theory when it's created in BASIC. You can also see why this might be controversial because it's assuming that all investors trade for the reason that they believe the stock price is accurate today or when they buy that stock or when they sell that stock. They're believing that, hey, this stock price is accurate and it's reflecting all available public information. Well, there might be a lot of investors that don't think that way. Like the Oracle of Omaha himself, he doesn't think that way, right? He thinks that maybe the stock price doesn't reflect all publicly available information. And that's the whole theory behind value investing, is that the price is wrong and I'm going to buy it while it's low and I'm going to sell it after the market reflects the information that I know or that I believe to be accurately reflecting the stock price, and I believe it's undervalued. That's why I'm going to buy it. So you see that there might be a lot of investors that don't rely on the price today being accurate. So there's been critics of this theory, and it was brought up again in Halliburton 2. And the court, the majority, Justice Roberts, did not want to rock the boat. He said, we're going to keep the fraud on the market theory. We're not going to get rid of it. We're going to do so because Congress has recognized this and kind of sanctioned this when it's passed subsequent securities laws, the PSLRA being that key one. It said that, Congress has recognized it, so we're going to keep it. He's also saying that this is really important because if we get rid of the fraud on the market presumption, then securities class actions just end. And this is a very important tool for policing fraud in the public markets. And if we don't have 10b-5 class actions, small individual suits probably aren't going to be enough to deter or police that fraud. That might be a controversial statement, but that's kind of what undergirds the opinion in Halliburton, saying that we're going to keep this decision there. And the critics just harp on, hey, look, Congress never wrote this. It's not really entitled to strong stare decisis consideration. We know that the efficient capital market hypothesis is not as accurate as we once thought. A lot of people think it's completely inaccurate. You've seen more and more people where you've seen movements in assets like cryptocurrency, assets like GameStop, and other Reddit stocks that have just moved like crazy for apparently no reason. So can we really say that investors rely on an accurate stock price, or is there just kind of people that are going for these hype cycles in the market? And so there's been pushback against the efficient capital market hypothesis, which undergirds the fraud on the market theory. And so, hey, if the efficient capital market hypothesis isn't accurate, well, then the fraud on the market theory needs to fall too. It's an interesting area of debate. Lots of scholarly discussions on this, and something to really kind of chew on when you think about the role of the securities laws in our country, and whether Congress should have more of a role here, whether these things are undergirded by theories that are economic theories that are flawed. Just an interesting topic. So thanks so much for watching this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.